You're gonna do it from there? Okay. If you want to, that's fine.
Okay.
The Jefferson County Court at Law number 2 is back in session with our trial docket. First case that we have is cause number 327-862. The case is styled the State of Texas versus James Chase Hendricks. Mr. Hendricks, is that your full name?
Yes, Your Honor.
Mr. Hendricks, would you please raise your right hand? Mr. Hendricks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do, Your Honor.
Mr. Hendricks, you may put your hand down. How are you doing, Mr. Hendricks?
I'm doing well. How are you?
I'm doing fine. Thanks for asking. Mr. Hendricks, you're here represented by your attorney, Mr. Dustin Galmore. Galmore, how are you doing?
Great, Judge. How you doing?
Okay. Mr. Hendricks, I have before me a document that is titled Information. Mr. Hendricks, do you, well, the state has filed this document titled Information. In this information, it alleges that on or about July 6th of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, state, are you abandoning the enhancement paragraph?
We are, Judge, as a part of this agreement.
Okay, Mr. Hendricks, the state is abandoning the enhancement paragraph, and that simply means that instead of being charged with a DWI second, you're charged with a DWI first. And instead of being charged with a Class A misdemeanor, you're being charged with a Class B misdemeanor. Mr. Hendricks, do you understand what you've been charged with?
Yes, sir.
And to discharge, Mr. Hendricks, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
Okay. Now, Mr. Hendricks, are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Hendricks, I have before me a document that is titled Misdemeanor Plea Admonishment. You'll notice at the top of this document, I wrote the statement that the state is abandoning the enhancement paragraph. Now, Mr. Hendricks, do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, Mr. Hendricks, there's a set of initials, JH, on a line that is next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, I did, Your Honor.
On page 2 of this same document, Mr. Hendricks, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, Your Honor.
And the next document that I have is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Hendricks, do you recognize this document?
Yes, I did.
Is this your signature above the line that's titled Defendant?
Yes, sir.
There's one box that's checked at the top of this document. This box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I did, Your Honor.
You have a discovery certification?
We do, Judge, right here. With the attached exhibit.
Okay, Mr. Hendricks, I also have before me a document that is titled Discovery Certification. Mr. Hendricks, do you recognize this document?
Yes, I did.
And is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Now, Mr. Hendricks, now, Mr. Hendricks, before you signed and initial those documents that I've just shown to you, that I just showed you, did your attorney go over those documents with you?
Yes, he did, Your Honor.
And did you read and understand everything in those documents?
Yes.
And is everything in those documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Hendricks, are you a U.S. citizen?
Yes, I am, Your Honor.
State, I have before me State's Exhibit number 1 and State's Exhibit number 2. State, you like to offer State's Exhibit 1 and 2?
Yes, Judge, we offer States Exhibit 1 and 2.
Without objection.
No objection, State's Exhibit number 1 and 2 are admitted. Mr. Galmore, you've advised and counseled Mr. Hendricks. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Hendricks, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, I am, Your Honor.
Has he provided fully effective and competent legal representation?
Yes, Your Honor.
Mr. Hendricks, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do you have a plea bargain agreement?
We do, Judge.
What is that agreement?
The agreement is 60 days in jail, probated for 9 months, with the following terms and conditions: $300 fine, 40 hours of community service, DWI education, drug and alcohol assessment, and interlock device to be installed during the term of probation.
He's in jail now.
Oh, is he? Oh, okay.
Okay, Mr. Hendricks, the state is offering that you serve,
60.
yeah, I was looking, I saw 62, 6, okay. The state is offering that you serve 60 days in the Jefferson County Jail. However, you will not have to serve any time in Jefferson County Jail on this case because you'll be placed on probation for 9 months. During the 9-month probationary period, you'll be required to pay a $300 fine plus court costs of $422. The total fine and court cost is $722. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay the DWI education class an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $165. Mr. Hendricks, will you be able to pay the $165?
Yes, Your Honor.
Now, Mr. Hendricks, you will also be required to perform 40 hours of community service, attend and complete a DWI class, and have a drug and alcohol assessment. You'll also be required to install a DWI interlock device on any vehicle that you own or operate. And as stated earlier, the state is waiving the enhancement paragraph. And so this is reduced from a DWI second to a DWI first. And you will also be required to adhere to all the other standard terms and conditions of your probation. Mr. Hendricks, do you understand the state's offer?
Yes, I do, Your Honor.
And now, do you accept the state's offer?
Yes, I do, Your Honor.
And just for the record, the state is also, you'll be required to install an interlock device on any vehicle that you own or operate. And I'll follow the plea bargain agreement that you have entered into with the state. Mr. Hendricks, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Yes, sir. To you, Your Honor.
Thank you.
Can I go ahead and get your right thumbprint on that page, please? Thank you.
Judge, which cause number are you going to take out first?
You wanna go ahead and get my
Dwayne Kelly, would you come forward? Court is in session in two cases. First case is cause number 331534. The second case is cause number 331770. Both cases are styled the state of Texas versus Dwayne Aubrey Kelly. Mr. Kelly, is that your full name?
Yes, sir.
How are you doing, Mr. Kelly?
All right.
Okay, Mr. Kelly, you're gonna have to speak up. The lady behind you is taking a record. Now, Mr. Kelly, you're here represented by your attorney, Mr. Todd LeBlanc. Mr. LeBlanc, how are you doing?
Doing fine. Thanks for asking.
That's good. Now, Mr. Kelly, in cause number 331534, I have before me an information that has been filed by the Jefferson County District Attorney's Office. And in this information, it alleges that on or about December 26th of 2021, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of indecent exposure. Mr. Kelly, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest to charges?
Yes, sir.
Mr. Kelly, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Mr. Kelly, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Kelly, there are a set of initials DK on a line next to a box that's checked nolo contingere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, Mr. Kelly, there is a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
And on the next document, Mr. Kelly, this document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Kelly, do you recognize this document?
Yes, sir.
And is that your signature above the line that is titled Defendant?
Yes, sir.
Now, Mr. Kelly, there are two boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And Mr. Kelly, I also have a document here on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
Now, Mr. Kelly, prior to signing and initialing these documents that I just went over with you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Kelly, are you a citizen of the United States?
Yes, sir.
Okay, Mr. State, I have before me States Exhibits 1 and 2. State, you like to offer States 1 and 2?
Yes, Judge, we'd like to offer states 1 and 2.
Any objections?
Yeah, no objection.
No objections. States Exhibits number 1 and 2 are admitted. Mr. LeBlanc, you've advised and counseled Mr. Kelly. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Mr. Kelly, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Kelly, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Judge, on.
And what is
both
that
cause
agreement?
numbers, 120 days in jail to run concurrent with credit for any time previously served.
Can I get his affidavit of images?
Yes, sir.
Mr. Kelly, the state is offering that you serve 120 days in the Jefferson County Jail. Mr. Kelly, you will be given credit for any time that you are entitled to get by law. The court cost in this case is $327. Mr. Kelly, will you be able to pay the $327?
No, sir.
Okay,
It's printing.
okay, Mr. Kelly, I have before me a document that is titled Affidavit of Indigence. You don't have to tell me.
Yeah.
And okay. Now, Mr. Kelly, I have before me a document that is titled Affidavit of Indigence. And Mr., could you hand this to your client? Mr. Kelly, the document is titled Affidavit of Indigence. That document was filled out at the Jefferson County Jail. I think Judge Sheffield signed this document on, and you, okay, let me ask him just, ask him if this is his signature.
I sure did.
Oh, that's your signature on the line that says defendant signature?
Yes, sir.
And I see here Judge Sheffield on February 18th of 2022 said that you met the eligibility requirements. What that basically meant that he found that you were indigent. And based off that finding, this court will find it. Now, have anything changed since this document was signed? Changed with you financially?
No,
Yeah.
sir.
Okay, so you still, so the court is going to find that you are still indigent, and based off that finding, the court costs in this case of $327 will be waived. That just simply means, Mr. Kelly, that you will not be required to pay it because the court has found that you are indigent pursuant to Article 42.15 of the Code of Criminal Procedure. The court cost is going to be waived. Now,
Thank you.
you are, now, Mr. Kelly, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Kelly, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Kelly, we will move on to your second case. And the second case, Mr. Kelly, is cause number 331770. And in this case, Mr. Kelly, the state has filed an information that allege that on or about December 26th of 2021, while you're in Jefferson County, Texas, you were charged with a Class A misdemeanor offense of evading arrest, detention. Mr. Kelly, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Kelly, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Kelly, I have before me a document that is titled Misdemeanor Pre-Admonishments. On this document, Mr. Kelly, this document is also labeled as State's Exhibit Number 1. Mr. Kelly, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Kelly, there's set of initials DK on a line next to a box that's checked nolo contendere, which means no contest. Do you understand?
Yes, sir.
And on page 3 of this document, there's a signature above the line that's titled Defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
Are these your initials? Well,
Yes,
let me back up. At the top of this document, there are two boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
And the second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And Mr. Kelly, I have another document before me. This document is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Kelly, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Judge, we'd like to offer States 1.
Any objections?
No objection, Your Honor.
No objection. State's Exhibit number 1 will be admitted. Mr. LeBlanc, you've advised and counsel, Mr. Kelly, is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Mr. Kelly, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Kelly, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Judge, we need to offer Exhibit 2 as well.
Okay, do you have any objections to State's Exhibit number 2 and
No
State's Exhibit number 1? No objections. State's Exhibits 1 and 2 are admitted. Now, Mr.
We do have a plea bargain agreement.
Well, State, do you have a plea bargain agreement?
We do, for 120 days in jail, to run concurrent in both cause numbers 331770 and 331534, with credit for any time previously served.
Okay. Next, okay, Mr. Kelly, the state is offering that you serve 120 days in the Jefferson County Jail. However, you will be given credit for any time that you are entitled to get by law. Now, the court cost in this case is $327. But you will not have to pay that $327 because that will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure because the court is finding that you're indigent, and it's so found that you were indigent in the previous case. And this case will run concurrent with cause number 331534. Mr. Kelly, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Kelly, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Kelly, this will conclude your case. Please follow the bailiff, and you have a blessed day. And Mr. Does he need to come over here?
Yes, sir.
Step over here?
Oh,
I have
sorry,
a-
sorry, sir.
She has to get some more information from you. Okay.
I'm retyping them right now.
May I be excused?
Yeah, Mr. LeBlanc, yes, you may be excused. Is this Trinity?
Yes, sir.
Okay,
Oh, wait a minute, Judge. Okay. Go on.
so we got him, Andrew Huber. What's his name? What's his name? Next to him.
Sonny.
Eckhart?
Yes, sir. It's Eckhart, ECKHART.
Okay,
I'm ready, Judge.
okay,
First name, Sonny.
okay. Is it Eckhart or Eckhart?
Eckhart, like heart.
Hart.
Yes, sir.
Okay. Okay, are we ready? Status, the court is in session in cause number 328274. The case is filed in the state of Texas versus Nathaniel Mark Trinzi. We have Mr. Nathaniel Mark Trinzi present in court with his attorney, Mr. Wright Kimler. We also have present State Assistant District Attorney, Mr. Blake Ham, and Attorney Sonny Eckhart. And just for the record, the panel is not in the courtroom, and the court has received information on juror number 6, stated that they were exposed to COVID-19 within the last 14 days. And so, Mr. Ham, does the state have any objections to this juror being excused?
No objection from the state, Judge.
Defense?
I make it optional with the jury, Your Honor. I'm not really asking to be excused. I'd be perfectly fine with the serving. I would be fine with the serving.
Okay, well, I think that we don't want to have somebody who's been directly exposed to COVID to be within the whole panel to expose everyone else at this time. Juror number 6 is going to be excused. Okay. Okay, so at this time, Mr. Bailey, you can go ahead on and you can excuse juror number 6. That person's name is Alicia Brown. And just for the record, Miss, would you come make sure that she signed this? I saw a check mark on that. I want to make sure that it's on that one and not on the last one, because it's in between lines. So it might be none of the above. So if it's none of the above, we're not going to excuse it. Just find out was she exposed or was she not exposed? She has a check mark. You see that check mark? Mr. Ham.
Yes, Your Honor.
And Mr. Kimber.
Yes,
Look like she got a check mark in between lines.
this is 6.
Yeah, that she may not be excused because it's kind of uncertain if she checked on the line that says none of the above or 14. She just got to check it's straddling between the lines. I just noticed she didn't put initials on anyone. She just put a check mark.
I've been accused of straddling.
Which
He did mean none of the above, sir. I got her initial.
okay.
Oh, so she's back in.
Yeah, she's back in.
All right.
Thank you. Okay. Defense, are you ready?
Ready?
State, are you ready?
Take ready, Judge.
You can call in the panel, start with the first four. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm presiding judge here in County Court at Law number 2. I know that you've been waiting for a while, but I can assure you that while you were outside, we was handling business here on the inside. Due to our COVID protocols, that's why we have you spaced out like you are spaced out. And the other thing is we have to televise everything on YouTube because pursuant to Article 1.24 Texas Code of Criminal Procedure, all trials and proceedings shall be public. And because the public is not allowed to come into the courtroom, they have to have access. And so access is being given through YouTube. And that's via directive from the Texas Code of the Texas Supreme Court and the Texas Code of Criminal Appeals here in Texas. So now you've been asked to come here for a criminal case here in County Court at Law number 2. Now, the first thing I would have to do is what we call an impanelment. An impanelment occurs before the jury is actually seated and selected on a criminal case. In County Court at Law number 2, like all courts, we have certain hours that we work. Our court hours are normally from 8 to 5, 8 a.m. to 5 p.m. in the evenings. Now, whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. Now, if you're selected, the case will be tried expeditiously, consistent with justice, which require a correct and careful trial. If selected as a jury, unless instructed otherwise, you will be permitted to separate at recess, for lunch, and at night. Now, there are some administrative things that I must handle before we get started. The first thing that I must do is administer to you the first of 2 oaths. And then what I'll do, I will ask everyone to raise their right hands. And then once I finish administering to you the oath, I would ask that each one of you please say, "I do." So at this time, we will ask that everyone here who is here to serve on the jury, please raise your right hand. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Okay, you may put your hand down. Now, ladies and gentlemen, the case that we have before us is styled Nathaniel Mark Trinsley, and it is cause number 328274. Now, as required by the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I will ask you a series of questions, but I do not want you to answer out these questions aloud. I just want you to answer them to yourself. And then once I finish asking the last question, I will ask, is anyone disqualified under the law? And if you think that you may be disqualified based on your answers to one of the questions, then just please raise your right hand. And once you raise your right hand, we'll identify you, and then we'll ask you to come up to the bench, and then we will discuss the matter outside of the presence of the other jurors. And when I mean outside the presence, we have a little noise device that sounds like this. And then we'll discuss the matter. Mics will be off, YouTube will be muted, and then we'll discuss the matter. And then once we finish discussing the matter, we'll determine whether or not you are disqualified or you are not disqualified. So I will ask you a series of questions. First question, except for failure, are you a qualified voter in Jefferson County, in the state of Texas, under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question I must ask, but do not take it personal. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the final question. Now, is anyone disqualified under the law? If you think you may be disqualified, you can just please raise your right hand. And then once we identify you, we'll have you to come up one at a time. And let the record reflect that no one has raised their hand, so all of the jurors are qualified. Now, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, please continue to remain seated. Now, I will ask these series of questions in the same format that I asked the last series. And at the end, I will ask if anyone believes or if anyone would like to claim one of the exemptions. First questions. Are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of United States military forces, serving on active duty and deployed to a location away from your home station and out of Jefferson County, Texas. If any of these exemptions apply to you, just please raise your right hand. Okay. Let the record reflect that no one has raised their right hand, and so no one is claiming an exemption. I will now move on to excuses. If any of you feel there is a reason why you cannot sit as a juror today, once I finish asking the questions and statements, we would ask that you will come up to the bench and discuss this matter outside of the public. Now, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state and the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here who is exercising an excuse? If you are, please raise your right hand. Let the record reflect that no juror has raised the right hand. Therefore, no juror is claiming an excuse. And just for the record, all 20 jurors are qualified. All 20 jurors did not claim an exemption and did not claim an excuse. Now, ladies and gentlemen of this jury panel, as I stated earlier, you have been summoned here to serve on a criminal case. The defendant in this case is Mr. Nathaniel Mark Trenzy. And Mr. Trenzy is sitting to my right with his attorney, Mr. Rife Kimball. The state in this case is represented by attorney Blake Ham, sitting first chair, and attorney Sonny Eckert, who is sitting second chair. And we have in the jury box, attorney Andrew Huber, who is also with the Jefferson County District Attorney's Office. The court reporter in this case is Ms. Carla Davis. She will be taking down everything being said, so speak up when you are answering or when you are asking questions. The bailiff in this case is Ms. Brenda Mosby. And the defendant in this case, Mr. Nathaniel Mark Trenzy, is charged by information with a Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Now, this is classified as a Class A misdemeanor offense, and the range of punishment for all Class A misdemeanors offense is confinement in the Jefferson County Jail for a period from 0 days all the way up to 365 days, which is 1 year, a fine from $0 on up to $4,000, or a person could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, please say so and I will ask you to come up to the bench so that we may discuss it more private. Is the state ready to proceed?
Stage ready, Your Honor.
Is the defendant ready to proceed?
Chris ready, Your Honor.
Mr. Ham, the panel is yours. You'll have 25 minutes.
Thank you, Judge.
Do you need more time? Is 25 is enough?
25 should be sufficient, Judge. Thank you.
Okay, let's do this. See, I'm gonna give everybody 30 minutes. Okay,
Very well.
all right. So at this time, well, okay, Mr. Ham, you need to do your PowerPoint.
Yes, Your Honor. Resume.
Okay. Okay.
Good afternoon. My name is Blake Ham. I represent Jefferson County, state of Texas, along with my co-counsel, Sonny Eckhart. I appreciate you being here very much. Heretofore, most recently, we'd have a jury selection would all take place in the big auditorium downstairs. We only recently started doing it in smaller groups like this. And down there, the judges, all the other attorneys would have told you that we can't do this without you, which is absolutely true, because neither myself nor Judge Holmes nor Mr. Kimler are going to decide whether or not Mr. Kinsey is guilty or innocent of the crime of which he's been accused. And if the jury of 6, there's going to be 6 people, it's a misdemeanor here, right? So there will be 6 and probably 1 alternate, which is different than a felony jury, usually like 12, right? 12, tried by 12. That's over in the felony court where, the typically more serious crimes are charged. That's not to say that the crime at issue in this lawsuit is not serious. We certainly believe that driving while intoxicated is a serious offense. So we call this jury selection. It is more accurately described as deselection. Both the state, myself and Mr. Eckhart and the defendant, Mr. Kimler, will have the opportunity to randomly strike 3 people. Okay. Now, if the state or Mr. Kimler chooses to strike someone, it's nothing, it's obviously nothing personal. He may be greatly relieved to administer. But the point is that we're trying to find the best 6 people to try this case. And everyone we recognize brings your own experiences, upbringing, religious convictions, convictions about DWI, for example, into this room. Everybody's different. Everybody's the same. It may be that there was a tragedy in your past and you just couldn't fairly decide no matter what the facts are. And if that's the situation, then maybe you're not the right person for this jury. Maybe you would be the right person for no one, because we're trying to find 6 people that can listen to the facts and apply them to the law fairly and render a decision. So that's all that said. So again, state of Texas versus Mr. Nathaniel Trinity, Blake Ham, Sonny Eckhart. So voir dire. Voir dire is a French jury selection is what we call it, but it means to speak the truth. Why? Because of the exact reason I just told you. So I'm going to try not to talk too much anymore. The crime that this trial is going to be about is driving while intoxicated. That's the base crime. There is an enhancement that the state could also prove, which is blood alcohol over a level of 0.15. Blood alcohol level over 0.15. So the base crime is DWI, driving while intoxicated. That's how the penal code defines it. You commit the offense if you're intoxicated while operating a motor vehicle in a public place. Okay, typically, these trials don't come down to were you operating a motor vehicle, sometimes they do, or were you in a public place, usually it comes down to were you intoxicated at the time. So to prove this, we have to show that this event occurred in Jefferson County, Texas. Oh, wrong defendant, Nathaniel Trenzy was operating a motor vehicle in a public place while intoxicated, and there's the enhancement for the BAC of 0.15 or more. Okay. So DWI can get slightly more complex than other misdemeanor crimes because we have all these definitions. One is, what does intoxicated mean? Well, there's basically three ways that the state can prove intoxication. Number one, that the person operating the motor vehicle has lost the normal use of their physical faculties due to the ingestion of alcohol or drug or some other dangerous drug. Second place, state can prove that the defendant was intoxicated because they lost the normal use of their mental faculties due to the ingestion of alcohol or drugs. Or finally, the baseline, most people know this, is we can show that while the person was operating the motor vehicle, they had a blood alcohol content level of 0.08. So that's the baseline. This particular case, the state's also seeking an enhancement to the baseline to show that the blood alcohol wasn't just over 0.08, it was over 0.15, so much higher. Okay, so the baseline DWI is a class B misdemeanor. It's punishable by up to 6 months in jail or a $2,000 fine. If you prove the enhancement, then you're subject to a class A misdemeanor, which is punishable by up to a year in jail and up for a $1,000 fine. Now, that's just a range of punishment. Of course, probation is also a punishment that can be given in a DWI case. Jail time isn't necessarily the answer. And I don't know which way the defendant's going to pick in this case.
We're required to agree with the judge.
Huh?
We want
To the judge? Okay, thank you, Mr. Gill. So, all right, so deciding the punishment would be out of the jury's hands. The defense is asked for the judge to decide the punishment if a jury finds the defendant guilty. Thank you. Okay, defendant's rights. Super important. We're not here to trample on rights. Of course, the defendants have a Fifth Amendment right not to testify. You can't hold that against them. Right? It's a constitutional right. Doesn't have to get on the stand. He has a right to remain silent, absolutely. He has a right to legal counsel. And he has it. He has a right to a jury trial, which is what's been selected. He is presumed innocent unless he's proven guilty. Right? So until the state, we put on our evidence to the jury and prove all the elements of this crime beyond a reasonable doubt, he's presumed innocent. He can subpoena people to testify. He has the right to testify. I mean, nobody's keeping him from testifying, but you can't hold it against him if he doesn't, because he has a Fifth Amendment right not to testify. All right, Verb To Prove. So a lot of times this gets difficult to understand because there's no definition beyond a reasonable doubt. It just is what it is. Right? In fact, the courts have told you that we cannot define what beyond a reasonable doubt means to jurors. You can't try to. So what does it mean? Well, it means what it says, beyond a reasonable doubt. Okay, we know it doesn't mean beyond all doubt. We would say that all the jurors, all we would ask is that when you're coming in, if you're picked to be on the jury, that you review all the evidence, right? Wait till everything's in, look at it, use your experiences, your life experiences, your life lessons, and apply your common sense to decide, as the state proven beyond any reasonable doubt, that the crime was committed. That's what we're asking. Okay, well, let's ignore that. Mr. Allen? Is it Mr. Allen? No, who's Mr. Allen?
Oh.
Sorry, I'm Mr. Allen. So I have a couple of goofy ways I try to explain beyond a reasonable doubt. Would you rather that I attempt the Indiana Jones method or the Beatty method?
Say that again.
Would you rather me try to explain beyond a reasonable doubt by talking about Indiana Jones or babies?
Yeah.
Indiana Jones or babies? No preference really?
No problem.
That's fine. Ms. Brown, what do you think?
Oh, let's go for, Indiana Jones.
Indiana Jones, okay, so, who here has not seen Indiana Jones? Raise your hand. Okay. Well, Indiana Jones is a movie I grew up with. He's like this adventurer guy, Harrison Ford, he played Han Solo in the movies, right? And he had a love interest, and her name was Marion, okay? And so Marion was the daughter of an archaeologist. She's a real go-getter. Indiana Jones and Marion get into lots of hijinks, and they're typically being chased by bad guys. In the movie, at about the 40-minute mark, Indiana and Marion are being chased by bad guys through some Egyptian street. They get separated. Marion runs into, she's being chased by a guy with a knife. She stops by and she grabs a frying pan out the street, and she runs into a darkened door. Right? You can't see in the room because it's dark. Okay? And then you hear the sound of metal hitting something. And then you see the bad guy fall out of the door and he falls down in the street. And then Marion walks out crying. Okay. The question is, if the state were to charge Marion with battering of a bad guy in the streets of Cairo, would we be able to prove it with that evidence alone beyond a reasonable doubt? Mr. Gilbert, what do you think? Probably. Why do you say probably?
I think it's a movie in my head. So you saw her enter, you saw him enter, you heard the sound, he fell out, and I think she steps out right after that. And so it's not really reasonable to assume that somebody else did it, and she was the one that was there at such a time frame.
Okay, but what other kinds of evidence might you want to see?
Fingerprints on the
Fingerprints?
firearm.
All right. Mr. Carthon, what do you think? Do you think that if we just show that video, that would be sufficient to prove to you beyond a reasonable doubt that Marion had hit that man in the face in front of him?
Can you speak up, sir?
I think you said yes, because they were the only two in the room, right? Okay, fair enough. So you use your common sense and say, yeah, she did it, right? Does anybody here have any doubts about, say, hey, there's a reasonable doubt here about whether or not this lady did that? Yes, sir, Mr. Sullivan. What do you think?
You didn't see it.
If you didn't see it, then,
There's a reasonable doubt, I don't see it.
okay, so what type of evidence would you want in that case for the state to bring proof to you?
It'd be very difficult.
Okay. Maybe if there was a video camera capturing the entire incident? Okay, but other than that, you're not sure if you could convict, right? Okay. Fair enough. Mr. Broadman? Mr. Broadman, what do you think?
All kinds of seen that movie.
I don't know, just picture in your head, so I'm accusing Marion of committing this crime, but the only evidence I have is what I explained.
I think there'd be some doubt.
Some doubt in your mind, not whether she did it?
The dark one, you know, she don't want it.
She doesn't testify, right? So, could have been somebody else. Okay. Fair enough. Ms. Hicks.
I think that there's enough circumstantial evidence, John, to be able to convict, because of, you said she stepped out right after he did, and no one else followed her, so. You have a weapon.
Okay, good. I'm with you. Mr. Kane, what do you think? Oh, right. I get it. So maybe eyewitnesses more. You want maybe some more. Okay, Ms. Murray, what do you think? No idea. All right, well, let me ask you this then. What kind of evidence would you want to see in a DWI trial to make up your mind as to whether or not somebody is driving while intoxicated? And I just jumped out there on this. Sorry about that. Let me put you on the spot. Blood alcohol report? Is there anything short of the blood alcohol report that you might, what if there was no blood alcohol report? Could you still, under any circumstance, find somebody guilty of driving while
The
intoxicated?
extra cost. That question's a improper commitment question.
Objection sustained.
Okay, so what other types of evidence would you like?
Did somebody see him driving? Intoxicated? I mean, how do we know was he stopped?
Right, we can't get into specific facts of this case. Okay, all right, so there are other things that you might look at. No, what kind of evidence would you like to see? And that sounds pretty typical, right?
Yeah, results of the blood alcohol test.
Fair enough. Yeah. Let's see. Ms. Arlen, we haven't seen on the front and center. What kind of things would you expect to see the state to show you in a DWI trial?
Well, just like everybody's already stated, blood alcohol content, if people see them driving and swerving erratically, dash cam video, if possible, if you didn't have the blood alcohol content, try the sobriety test with the camera.
All good answers. Typical DWI kind of stuff. All right, let's see. Swing back to this case. How would you like to see somebody, what kind of evidence would you want to see in the DWI trial?
So I probably want to see a phone with false statements, but it allows you to see their behavior up close. I've bartended for 5 years, so I'm familiar with that. And I feel like you can tell the major signs of intoxication based on someone's behavior. So that, and maybe if there were witnesses seeing him consume alcohol or prior to driving, or proof that this person bought alcohol, or drank alcohol.
Low budget, right? Oh, just circumstantial things that you can use.
Sam, you have 15 more minutes.
We chose not to do that. Okay. So. How would you tell if somebody was involved? I mean, what things would you look at to make a determination?
You mean like if I'm out to dinner or?
If you, well, yeah, let's say you're out, let's say you're out to dinner with friends. And you're like, wonder if that guy is drunk right now. What would you be looking for?
Slurred speech, not, their balance is off. Maybe a little loud compared to other people. Maybe a little angry, with challenge.
Just normal stuff, right? I mean, does anybody here not drink alcohol? Okay. We have quite a few. We don't drink all, the majority have had a drink every now and then. And even those who don't drink, have y'all been around people who are drinking ever? Yes. Okay, yeah, so we've seen. This man, do you think that DWI is an important crime?
Yes,
And why is that?
well, if it's a an accident, bodily harm or death,
Absolutely. I mean, cars are big, heavy pieces of metal. This jumps. What about you? Do you think DWI is an important crime for police officers to patrol?
Absolutely,
And why do you think that?
because I don't want anyone to injure my loved ones on the highway or, out, probably out for a bad activity, and someone's going to drop.
And what makes you think that perhaps someone who has been drinking, and driving might injure one of your loved ones
They're driving.
while intoxicated? But what is it about the intoxication that makes them more or less dangerous in your mind?
Intoxicated, if they're intoxicated at home, that's different. Once you have too many drinks, you're on a highway.
That's right, because, reaction times can be slow. Right? Mr. Zapata, what do you think? DWI important or not?
Yes, sir.
You can react like that, but you would if you weren't.
I obviously concur. I'm just saying, so, they call it a driver's license, right? Not a driving right, it's a license. What does that term mean to you in this context? License.
You have the right to get in a vehicle and drive it.
Right. But you also have agreed to comply with certain laws.
Yes.
For that license, correct? Now, this new DWI, important or not?
Yes.
Why?
Because driving is a responsibility, and you have to be up to that responsibility.
We all trust each other if we have to, if we're gonna get out on the road, right? Okay, Mr. Harrington. How about you? What do you think about DWIs?
As far as I think it's,
I mean, is it a big deal, not a big deal? Does it depend?
it's a big deal, because you're in charge of a motor vehicle. It's important that you have the right, what's it called, to be in charge of that vehicle.
You're in full, whatever your competency, ability to drive is, you've got a full use of it. Right?
10 more minutes.
Okay. Witnesses. Now, the trial might have witnesses in it, and some of them might be police officers. See this one. Do you think that a police officer, if he gets up, or she gets up to testify on the stand, begins with more or less credibility than your average citizen? You think so? Why is that?
Well, they've taken it forward.
They've taken it up to protect the service. And I agree with that. I definitely agree that, we should expect it, to be honest. Mr. Knowles, if a police officer gets up there, are you going to start off giving that person more credibility than anybody else?
We see what the evidence.
I'm with you, right? I agree with both of them. I agree that you should expect them to be more credible, but you're going to have to listen to what they say and make up your own minds as to whether or not you believe that this guy or gal is saying, regardless whether they're wearing a badge or not, because they're all people just like us. So with this credibility rules, wait until they talk before you make up your mind, because you or whoever's on this jury, aside from being the people who are going to decide guilt or innocence, you're the sole judge of the credibility of any of the witnesses that you would see, whether they're a police officer or not. They should all start off with the same level of credibility, and then as they talk, you can use your own judgment as to whether that should go up or down. So this line, what are some things that might make a person lose credibility in your mind as they're testifying?
Lack of consistency. A failure or preference not to recall or to remember.
I understand that. You're like, hey, so, well, I don't really remember that. Then you start, I've heard that before. Okay. All right, just remember, if you're on the jury, everybody starts off eating clean. Do that. All right, well, again, thank you very much for coming. I really appreciate that you're here. Couldn't do it without you. Thank you.
Mr. Kimmerler, the panel is yours. You have 30 minutes.
Good afternoon. Like lively bunch. Why are y'all here? Why are you here? Miss Brown, why are you here?
Because I was summoned.
Are you summoned? All right.
Yeah, I was summoned.
Anybody here? Everybody was summoned, right? Why don't you just ignore it? Well, if nothing happens to you.
Well, it's my civic duty to be here.
Okay, so if I told you nothing would happen to you, if you ignored the summons, you still would have come, right?
Yes.
What about you, Miss Hicks? Would you still come, knowing that nothing would happen to you if you ignored the summons?
Yeah, sure.
I'm sorry, what?
I'm,
Hicks. See, it got me confused. For years, we just would have two lines of people, and I could keep track of that. But as you get older, your mind starts to better. But would you still, Miss Huff, would you still come, even if I told you that nothing would happen to you? I'm gonna send, Officer Mosby, had over there, she's not gonna come out there. You come get you, your ride.
sorry about civic duty. That's my whole career, everything.
Okay. What about you, Miss, make sure I'm right, Niven, you back, would you have come? Is anybody here who wouldn't have come? Or is willing to admit that they wouldn't have come? If I represent to you that nothing adverse will occur to you if you ignore the sign.
Oh, man, didn't make it.
Mr. Knowles, is that right?
Yeah, just got.
Probably, maybe might, next time you might not. When you
I
get
just
the
got
sign.
back from Vegas about 5 hours.
Right, I understand. The circumstances. Right. About you, Ms. Jones, you back, maybe?
I think I read.
Yeah?
I read.
Okay, some people can't miss work, that's a reason, if you have an economic hardship, you raise that. The judge instructed you that some people work for themselves, they don't get paid, to be down here. Well, why is it important to show up, Mr. Henry, why is it important to show up?
It's your civic duty.
And why do you think it's your civic duty?
It's
What does it mean when you say it's your civic duty? It's just an obligation,
obligation to your community, and to your county.
and why do you think that they've made it, who's made it an obligation? The government?
Yes.
Okay. And you just do it because you feel like you're obligated to do it, it's your duty, your obligation, like maybe stand up when the national anthem's played, that kind of thing. All right. What about you, Mr. Kane? Kane? Yeah, why would you come? Why do you come? Knowing that nothing's gonna happen to you if you don't show up?
Like they said, like my obligation.
I'm sorry,
Like they said, I feel like it's my obligation.
your obligation? What about you, Mr. Gilbert?
For both the state and for the defendant.
What do you mean?
It's one of the few places in the world where we do trials by jury. It's a privilege to have that.
Sure. It's not just that it's an obligation, it's a privilege, right?
That's correct.
What do you think would happen if people quit showing up? We couldn't get, which we didn't for a long time, we had juries, right? 2 years ago, difficult to get juries. What do you think happens then?
Things hang over defendants' heads for a long time. The state's not able to process, justice is delayed.
Jails get backed up with people.
Justice delayed is justice denied.
Right. Well, why not just do away with these dang juries? They're such a pain in the neck. We get people down here, you have to have them before you get the sign a case. We'll just, maybe maybe get 3 or 4, well, it'd have to be 3 or 5 judges, I guess you want an odd number. Why don't we just let judges decide?
Because one of our rights is that we get to have a jury of our peers. We get the opportunity to let them decide our fate, which is a much better deal
Well,
than somebody else.
why is it important to let people from the community make the decision whether or not to convict somebody than let even these learned people of the law, these judges, or other people make the decision whether or not to convict somebody?
The best way I can answer that is, I was in the military, and unless you get to a general court martial, it doesn't happen that way.
Right.
It's not by your peers, it's not by those things, and in those cases that, they may not put themselves in your place as much as they necessarily otherwise would. Any of us could be at some time accused of crime.
What's the result of a conviction? Anybody? What's the result or the consequence of convicting somebody? Mr. Sullivan, what do you think? What's the consequences of convicting somebody?
Consequences are the punishment for the actions of the crime.
Punishment, right? And what can punishment consist of?
It can consist of fines, jail time.
And just in general, not just in this vehicle, but in general, what can it consist of?
Penalties that you created on your own terms.
Well, I mean, I'm thinking more in the statutory concrete sense. You could be sentenced to prison.
You could go to prison.
You could be executed. Never like that. I mean, we all can agree that there's severe consequences. I mean, not misdemeanor, varying consequences, up to severe consequences for a conviction.
Yeah.
So the result of a conviction can be a deprivation of liberty. So what's the most important thing to you in life? Just generally speaking. Family. And after that, maybe health. I mean, we can think of some other
Family, God.
health. Right?
Yeah.
What about freedom?
Everyone should have freedom, especially in this day and time.
What do you eat for breakfast?
Nothing.
Nothing. Well, you chose to eat.
That's right.
Right?
Yeah.
Right. That was a choice. You wanted to have waffles or bacon and eggs, you could have. You could choose. I mean, that's a trivial example, but it's one of the few things you choose. You choose what time to get up, I guess, if you're not working. Choose what you watch on TV. You choose where to go, all those little choices, everything. Can you imagine a situation where that's taken away from you and you're institutionalized, and all those decisions you make for everything from the time you get up, to what you eat, to what you wear, where you go, how you walk, all those things you decide. At the end of the day, the door clicks shut and you're confined in a cell. Collectively, that's the consequences, right? And that's why juries in our system decide that, not the government, not the state. The jury, the people have that authority, that power to make that decision. Now, do juries find people innocent? Do they make that determination? You ever heard, especially the jury found him innocent? Miss Newman, you're shaking your head no. The jury found people innocent?
Not guilty.
Not guilty. Okay. So right now, what would your vote be in this case? Guilty or not guilty?
I have no idea. I don't know any.
So what's the verdict then?
We can have
Yeah, you can't. If you don't have any information, what's the verdict? Is it innocent? Am I asking you to say
Oh, he's
this man is he?
innocent until proven guilty.
Okay, so has he been proven guilty?
No.
So what's the verdict?
Oh, then that would be in.
No. I'm sorry. But the verdict will be not guilty, right? Yeah, I mean, I'm trying to trick you here. Because it's not guilty means the person is innocent. Didn't do it, didn't do, not innocent. Was OJ innocent? Was OJ innocent? Was OJ not guilty? Right, but was he innocent? Right, there's a difference. My point is, juries don't make the determination whether somebody's innocent or not. He's presumed the person, anybody accused of an offense, it's just an accusation. And the presumption, and Judge Holmes is going to instruct you that the defendant is presumed to be innocent. Presumed to have done nothing wrong, periods of driven snow, innocent, right? And it's up to the state to introduce evidence sufficient to convince you beyond a reasonable doubt that every element of the offense that they're required to prove is has been proved beyond a reasonable doubt. And then if they've done that, your verdict is guilty. If they haven't done that, there's a reasonable doubt that remains after all their evidence in your mind, then the verdict's not guilty. Now, if you vote guilty, does that mean 100% the person did what the state's accusing them of? Yes, ma'am.
Okay, ask me that again.
Does it mean, if you vote guilty, does that mean certainty that they did it?
That I thought so beyond a reasonable doubt.
Right. Is reasonable doubt less, beyond reasonable doubt less than absolute certainty? Anybody? Sorry?
Yes.
What? Tell me.
Beyond a reasonable doubt is less than absolute certainty.
Right. You think there's people that have been convicted, found guilty on a beyond a reasonable doubt standard that actually are innocent?
Absolutely.
Yeah. Not 100%. So just like on the not guilty side, there's not certainty. Just on the guilty side, there's not certainty. Juries aren't expected to make those kind of calls on the absolute end of things. You do the best that you can with what you got. And the idea is that this proof beyond a reasonable doubt standard is supposed to be your guiding principle to evaluate the evidence in the case. Now, the problem with that is there used to be a definition that was given for years. And it was, and I know it by heart because I argued it countless times in front of juries, is proof of such a convincing nature that you would be willing to rely and act upon without hesitation, and most importantly, without fear. That was the definition that was given. So my argument, a lot of defense lawyers, do you feel yourself hesitating, hesitation? Well, they finally, the Court of Criminal Appeals issued a decision and said, well, you know what? We're not gonna define proof beyond a reasonable doubt anymore. We're gonna leave it up to the individual jurors to decide what it is. Now, the judge is gonna tell you it's not proof beyond all possible doubt. So he'll tell you what it's not. It's not absolute certainty. It's not proof beyond all possible doubt, but beyond that, you don't get any guidance as to what it is. And what that means is that each of you are going to have to decide for yourselves how high of a standard proof beyond a reasonable doubt is. Ms. Leon, is that right? What do you think proof beyond a reasonable doubt is? What is that? How high of a standard is that? Do you think?
I think after looking at all or listening to all the evidence, that it is so high of a standard that you are pretty sure.
Pretty sure?
Pretty sure, because it's not absolute.
So there's, you don't think there's a lot of space between pretty sure and absolute? Maybe really, 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 really sure, maybe? Not quite certain, but beyond pretty sure?
Well, pretty sure, really, really sure, but it's not absolute.
It's not absolute. Well, we know that it's not absolute. So something less than absolute, I guess. Is the best one. What about you, Mr. Clifton? What do you think? Proof beyond a reasonable doubt. What's that mean to you? Clifton, right? What's Alan, right? Alan, okay. What do you think? I don't hear it.
Understanding, well, I don't really know what the question was you asked.
What's proof beyond a reasonable doubt mean? How would,
What?
Proof beyond a reasonable doubt, what's that mean? How would you define that? How certain, or how sure do you have to be before you convict someone? Think it's a lot or a little bit or middle or what where would it be?
I think it's opinion of the person, I'd have to be pretty sure.
Pretty sure, all right, Ms. Clifton, something other than pretty sure?
Pretty high percentage.
Pretty high percent, how high of a percent?
90%.
90, all right. What about you, Mr. Sullivan? What's your name? What that?
Broadnet?
Broadnet.
Yeah.
All right, what do you think, Mr. Broadnet? Oh,
Well, I agree with the pretty sure, a high percent. I don't know that you could ever come up with 100%.
What about like the next day after the trial, after you voted, you may have convicted somebody and you're brushing your teeth, looking in the mirror in the morning, you're thinking, geez, did I do the right thing? You're second guessing yourself. You ever find that when you make a decision, you may second guess the decision? Is this the kind of thing you want to second guess yourself on? You ask yourself when you're saying, I want to be sure enough where I'm not second guessing myself. I'm not worried that I may do the right thing, to make the right decision. That's called proof to a moral certainty. That's not something you're ever gonna find in the legal book. But it's just knowing that you did the right things, you know, you're not gonna second. And I guess everybody can agree, because we talked about punishment and consequence and guilty verdict, there's a high standard, it should be a high standard, right? You know, disagree with that? Proof beyond the reasonable doubt should be a high standard for the sake of me. Anybody? Not possible, anybody disagree with that? Anybody? And you're just, Murray, is that right? Disagree with that, or you agree with that? High standard? Mr. Hanson, should be high standard? That's it. All right. What about you, Miss Brown? What do you think? High standard? Now, this is a driving while intoxicated document, obviously, talking about that. Anybody here have a loved one or injured or unfortunately killed? Anybody know anybody that's been injured or killed by intoxicated?
Yeah, 15 more minutes.
Okay. All right, let's start with you, Ms. Aldridge. I'm sorry, do you want to?
It was my brother-in-law's granddaughter was killed in a drunk driver hit them. They was called over 5 teenagers. And she was
How long was
hopefully 8 years ago.
Was that here locally or was that?
Um,
Okay, I remember the 5, I think it killed all 5 of them. Anything about that situation or that set of circumstances that you think will compare your ability to be fair and impartial and driving on a positive?
No, I really can't, because I didn't hear the court whenever it went to trial. I didn't know the courts to hear everything, but I mean, it's kind of hard to say that I would be impartial because of the fact that, you know, he was proven that he was driving under the influence.
I don't mean, I'm just in general, being a juror in a case. It's like if I, wake up in the morning, my car's been broken into, and I come up here and I got a burglary with a vehicle case. I'm still gonna be ticked off of my car was broken.
Yeah.
So, I mean, do you think that, and again, only you know, I mean, could you be?
I think if I listened to that evidence, I would gear it towards what the evidence is.
Okay.
Everybody's situation is different.
Correct.
Every trial is different.
So you're able to give somebody accused of the DWI for?
Oh, absolutely.
All right. Miss Clifton, you want, again, like Ms. Aldridge, go into a little bit of the circumstances and what that was?
My son's best friend was the
Okay, how long ago was that? Was that here in Jefferson County or? Again, anything about that situation or circumstances that you think, looking into yourself, that would compare your ability to be very impartial in the DWI trial as a juror? You think that you could do? Again, you were able to set aside any residual animosity you might have just based on that circumstance in general, where a person is accused of that offense could expect you to fairly impartially weigh the evidence. Could you do that? And I like to think I could do a lot of things. I like to think I could be president. But, I mean, could I or not? Realistically, no. But what do you say? You'd like to think you could, couldn't you? You don't know?
I don't know in this moment.
Right. What about when you get on the jury, you start hearing evidence, you think that can bring back memories and maybe trigger something in you where you think I can't. And again, now's the time to get that out, because once you're in the jury, stuff. Now, and look, I'm sure you wanted to have a fair trial, right?
I do.
Okay, well, do you think that you could set aside any residual feelings you might have and be fair and impartial juror on a DWI case? Okay. And then one person, then this, then,
It was a long time ago, but I had a high school friend, she was driving.
how long was, well, roughly,
Maybe 8, kind of long.
that long back. And you probably asked both Ms. Arge and Ms. Clifton, same set of questions. What do you think? You do fair and impartial draw, set that aside. Anyone else? Yes, sir.
I had
Mr.
a niece involved in the ATV accident.
So the 18-wheeler,
ATV.
oh, ATV, I see. All right. Well, anything about that experience, what you think was very forward, sir?
It's pretty rough.
Do you think
Like
it's,
a month ago.
oh, was that recent?
Yeah.
Right. Do you think based upon that you may not be able to be a fair and impartial juror to do that? And that's not to say another type of case would be a great juror, just this particular type of case.
You know what to say.
Sir,
You know what to say.
hard to say. All right. Was it good or bad? All right, I think that's about all I have. And I always end at the end, if you don't have any questions for me, I think that's fair, if you want to ask me any questions. All right, I'll give y'all some time back. Thanks.
Hold on a minute. Let me, we're gonna have to. So at this time, ladies and gentlemen, please follow the bailiff to the hall. You can go out both either door.
I'm kind of joking around. You do, sometimes you get. I can't explain it. Never have to answer my color challenge, like, then you go vibe, you know.
I think it's a legitimate thing. I go to marathon. Seems like a pretty,
I'm sure.
pretty swell kid. Kid's all right. I don't know what your
About
problem is.
non-drinkers though, man. That's the thing. Good agenda. How many people go to the pump train? Just-
Line, I just met 3.
My father was on it, you know, and I would want